The Loughlin Indictment. To be precise, the third superseding indictment. I don't know what the record is for superseding indictments, but let's look at a couple of reasons it might happen in a particular case. Look at all these defendants, and along the line you've seen there have been some parents who have pled guilty and have been sentenced. Felicity Huffman already went to prison, got out after 11 days of her 14-day sentence, I think. And she's officially a felon, I believe. Picture it, 2 weeks sentenced for pleading guilty to a felony, as I believe she did. I'm not certain. I didn't look up her case details. But here at number 14, you have Lori Loughlin, and at number 8, you have Massimo Giannulli, her husband. And this is the third superseding indictment. And you come at this from the standpoint of the Department of Justice, and it might be that, well, you know, we got 4 or 5 parents to plead guilty. What do you say we revise the indictment? Because what else did we get? We got some that won't plead guilty, like Lori Loughlin and her spouse, Giannulli. And so why don't we revise the indictment? Instead of one charge, let's throw the book at them. And they named this couple, both of them, as defendants to counts 1, 2, and 3. And let me tell you where you can find this. Let's see. Let's go briefly to takefromcaesar.us. No, let's not. I'm going to give you an instruction on how to find it on the web. Takefromcaesar.us. Go to the home page, scroll down to the links below the photograph of the $25,000 check. And right below that, you'll see 2 sets of links. On the right-hand side, one of the links is Indictment. Click on Indictments and scroll down to the bottom of the page that pops up, and you'll find the Lori Loughlin Indictment. And you'll be able to download it there. It's exactly the document we're looking at for the purposes of this tutorial. Now, the other reason, like I said, let's amp up the pressure on the defendants that are left, because they've had every chance to plead guilty, and 86 the ones that are already pleading guilty, entering agreements. And to the best of my knowledge, the counts 1, 2, and 3, that's 45 years worth of charges that Lori Loughlin now faces. And the reason I'm keying on her is because I like her. She does nice, wholesome work, and she's always just struck me as a very nice lady. And I hate to see her in this trouble, but you spend $500,000 to defraud a university, and there's bound to be problems. And I don't mean small ones. There's 45 years worth of charges brought against everyone on this list, her and her spouse. And you got the thought bubble over here that says Lori Loughlin and spouse, their conduct is on page 20. I can't get my window to pop up. Their conduct begins on page 20. Count 1, about the conduct, the first allegation, this count 1, conspiracy to commit mail and wire fraud and honest services fraud, begins on page 49. Lori Loughlin is in counts 1, 2, and 3, beginning on page 49. So we'll scroll forward to, well, first, conspiracy to commit mail and wire fraud and honest services mail and wire fraud. 18 U.S.C. 1349. Don't do that. Count 2, conspiracy to commit federal programs bribery. That's conspiracy to defraud the United States, 18 U.S.C. 371. And count 3, 18 U.S.C. 1956 A2A is the particular violation. 1956H provides for the penalties. And those are the only three we're going to look at, the only three that pertain to Lori Loughlin and spouse. And let's scroll forward, see third superseding indictment. And we're going to scroll forward to page 20 of the third superseding indictment. Page 20. These are the facts that have to justify the charges in what's called a four corners analysis of the indictment. Does the indictment sufficiently state an offense? Paragraph 130, and there's only a couple pages of facts here that we have to read through, and these are the facts upon which the three allegations or accusations are based when it comes to her counts, beginning on page 49 of this 61-page indictment. Paragraph 130. In or about 2016 and 2017, Giannulli and Loughlin, I'll just say Loughlin, agreed with Singer to pay an amount ultimately totaling $500,000 to facilitate the admission of their two daughters in USC as purported crew recruits. Her spouse had previously been introduced to Singer by an unindicted co-conspirator. That might be another reason for a third superseding indictment, is that somebody's agreed to rat other people out. Like Singer, the guy they sent all this money to. He's got a big vested interest in, he won't be an unindicted co-conspirator, so he's not the person they're talking about there, but he's got a vested interest in reducing his charges. Paragraph 131. On or about April 22nd, 2016, Giannulli sent an email and copied Lori Loughlin to Singer, the man taking the bribes, noting, I have some concerns and want to fully understand the game plan and make sure we have a roadmap for success as it relates to our older daughter and getting her into a school other than Arizona State University. Singer responded, if you want USC, I have the game plan ready to go into motion. Call me to discuss it. End quote. 132. On or about August 18, 2016, Singer sent an email to Giannulli and Loughlin stating that he needed a copy of their older daughter's transcript and test scores, quote, very soon while I create a Coxswain portfolio for her. It would probably help to get a picture of her on an ERG in workout clothes like a real athlete, end quote. And the spouse replied, fantastic, we'll get all. I will create a Coxswain portfolio for her. That's the person that sits in the back of the boat and barks a rhythm at the rowers. Paragraph 133. On or about September 7, 2016, Giannulli sent Singer an email attaching a photograph of his older daughter on an ergometer. Paragraph 134. On or about October 27th, that's a month later, month and a half, 2016, Heinel presented the Giannulli's older daughter to the USC Subcommittee for Athletic Commissions and, based on falsified athletic credentials, obtained the subcommittee's approval to admit her to USC as a crew recruit. 135. On or about October 29, 2016, Singer emailed the spouse of Lori Loughlin, please send $50,000 payment to the person below, Donna Heinel, Senior Women's Associate Athletic Director, care of USC Athletics. So $50,000 is going to go to Donna. Remember, these are the facts that the government claims justifies 45 years worth of charges. And it's not good. It just doesn't look good for Lori Loughlin. 136. On or about November 1st, 2016, Giannulli told Singer, quote, I told biz manager to FedEx the payment today, end quote. Paragraph 137. On or about March 30th, 2017, Singer's accountant emailed a $200,000 invoice to Giannulli and Loughlin. The invoice thanks Giannulli and Loughlin for their pledge to KWF, it's a foundation, and further stated that their private contribution of $200,000 was now due. 138. On or about April 2nd, 2017, in response to the email attaching the $200,000 invoice, Loughlin's spouse emailed Singer's accountant and Loughlin, quote, "We are currently on holiday in the Bahamas, but will gladly handle this when home next week." Paragraph 139. On or about April 10th, 2017, the spouse forwarded the $200,000 invoice to his own accountant for payment, writing, quote, "Good news, my daughter is in USC. Bad is I had to work the system," end quote. 140. On or about the same day after Giannulli's daughter received a formal acceptance letter from USC, Giannulli wired $200,000 to the foundation. On or about April 10th, 2017, Giannulli emailed Singer, copying Loughlin, quote, "I want to thank you again for your great work with our older daughter. She is very excited, and both Lori and I are very appreciative of your efforts and the end result," end quote. When Singer responded by asking if there was a, quote, "similar need anywhere so we do not lose a spot," end quote, for their younger daughter, Loughlin replied, "Yes, USC for our younger daughter." 142. On or about July 14th, 2017, Singer directed Yankee to prepare a falsified crew profile. That's got to be their Photoshop expert for the Giannulli's younger daughter. Paragraph 143. On or about July 16th, 2017, Singer emailed Giannulli and Loughlin requesting that they send an action picture for the crew profile. Singer indicated that the profile would present their younger daughter falsely as a crew coxswain for the LA Marina Club team. 144. On or about July 28, 2017, Giannulli, copying Loughlin, emailed Singer a photograph of their younger daughter on an ergometer. 145. On or about November 2nd, 2017, so it's about a year and a couple of weeks since the first track date of emails to these people. On or about November 2nd, 2017, Heinel presented the Giannulli's younger daughter to the USC Subcommittee for Athletic Admissions and, based on the falsified athletic credentials, obtained the subcommittee's approval to admit her to USC as a crew recruit. 146. On or about November 29, 2017, Singer directed Giannulli and Loughlin to send, quote, "send a $50,000 check to USC at the address below. Additionally, the rest of the $200K will be paid to our foundation as a 501c3 after your younger daughter receives her final letter in March," end quote. Paragraph 147. On or about December 5th, 2017, the spouse directed his business manager to send a $50,000 check to Heinel. Paragraph 148. On or about February 6th, 2018, Giannulli wired $200,000 to the foundation. 149. On or about October 25th, 2018, Singer called the spouse from Boston, Massachusetts. During that call, Singer told Giannulli, quote, "Donna called me a couple weeks ago and says, hey, going forward, can you use that same format you used for their older daughter and their younger daughter and the regattas that you put in there for any girls going forward that don't row crew?" So it's funny how I thought I was just making stuff up, end quote. And Loughlin's spouse replied, right. Paragraph 150. On or about November 29th, 2018, Singer called Loughlin from Boston, Massachusetts. During the call, Singer said in sum and substance that the foundation was being audited by the IRS, which was asking about the two payments of the $200,000 by the Giannullis. Singer added, quote, "So I just want to make sure that you know that, one, that you're probably going to get a call, and that I have not told them anything about the girls going through the side door through crew, even though they didn't do crew to get into USC. So that is, all I told them was that you guys made a donation to our foundation to help underserved kids. Loughlin replied, yeah, the IRS is auditing the foundation. Where did these payments come from? What is it for? Oh, the payments were made at the same time their girls got admitted to the college falsely with photoshopped credentials? Yeah, that. This is the sum of the facts upon which the government bases the 3 charges beginning on page 49. Okay? Now, let's see, page 49. I've only looked at these statutes a couple times. This is a pretty advanced indictment as indictments go, in my experience. Count 1, conspiracy to commit mail fraud and wire fraud and honest services mail fraud and wire fraud. 1 section 1349. And, this one says if somebody conspires to violate this chapter, they get as much in prison as they would have gotten under the statute they violated. So I can't tell if this imposes 40 years or just 20. The grand jury realleges and incorporates by reference paragraphs 1 through 244 of this third superseding indictment. From in or about 2007 through in or about February 2019, in the District of Massachusetts and elsewhere, the defendants, and there they are right from the caption, not all of them. And here's the 1349, attempt and conspiracy. Any person who attempts and conspires to commit an offense under this chapter shall be subject to the same penalties as those prescribed for the offense. So they can charge you with the offense, and if you attempted it and conspired, they can double it. Look at that. That's the way I read that. It's something that I know the DOJ wants to do to innocent people, so you can read these facts on your own time. I'll give you a chance to pause right here, and I'll read this first paragraph. Mail fraud and honest services mail fraud, that is, having devised and intending to devise a scheme and artifice to defraud and to obtain money and property, to wit, ACT and SAT and other standardized test and test scores, and admission to the universities by means of materially false and fraudulent pretenses, representations, and promises, and to defraud and deprive variously ACT Incorporated, the College Board, and the universities of their right to the honest and faithful services of their test administrators, athletic coaches, and university administrators through bribes and kickbacks, did, for the purposes of executing and attempting to execute the scheme, deposit and cause to be deposited any matter or thing whatever to be sent and delivered by any private and commercial interstate carrier. That's the U.S. Postal System, UPS, FedEx, in violation of these 2 statutes. And I think those are 20 years each. So a conspiracy to commit both of these crimes. The conspiracy carries as much as you get. And they just, they only mentioned 1349. They didn't charge her with these 2 statutes. 1341, mail fraud. So I can't tell you exactly what they were thinking. If they're trying to, it's only 1 count, and so I don't believe they're trying to bring the full 40 years, 20 years under each of these statutes. But this second paragraph, why don't you pause right now if you want to read it. And there's the honest services statute, 1349, conspiracy, and this is all language right out of the statute. They're building a case based on only those 3 pages of facts. Count 2, 18 U.S.C. 371, conspiracy to commit an offense or to defraud the United States. If two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to effect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. If, however, the offense, the commission of which is the object of the conspiracy, is a misdemeanor only, the punishment for such conspiracy shall not exceed the maximum punishment provided for such misdemeanor. And this carries a max of 5 years. And we don't have every defendant in this list, but we do have Lori and spouse. From in or about 2007 through in or about February 2019, they did these things. Conspired with others, known and unknown to the grand jury, to commit federal programs bribery, that is, to corruptly give, offer, and agree to give anything of value to any person with intent to influence and reward an agent of an organization, to wit, agents of USC, in connection with any business transaction and series of transactions of USC involving anything of value of $5,000 or more. That is, in exchange for facilitating the admission to USC for the defendant's children, where USC received benefits in excess of $10,000 under federal programs involving grants, contracts, subsidies, loan guarantees, insurance, and other forms of federal assistance in any 1 year period in violation of this section. And they say it constitutes a conspiracy to defraud the United States, or conspiracy to commit an offense. Count 3, money laundering. I remind you that 1956H provides for the punishment. 1956A2A is where they trigger the charge. So here we have A2A, laundering of monetary instruments, A2. Whoever transports, transmits, or transfers, or attempts to transport, transmit, or transfer a monetary instrument or funds from a place in the United States to or through a place outside of the United States, or to a place in the United States from or through a place outside of the United States. I don't know what the hell's all that's about. Get to the point. If you have to, Congress, why don't you just list all the countries that aren't the United States? A, with the intent to promote the carrying on of specified unlawful activities. See how easy they flagged her for 20 years? Subsection H, any person who conspires to commit any offense defined in this section or section 1957 shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. So if you even think about it and take an act to put it into effect, bingo, 20 years, whether you succeed or not. From between those two times, 2011 and 2019, the defendants did this. Now, how can they go back all the way to 2011? Because they're alleging a conspiracy. And the statute of limitations on a conspiracy doesn't begin to run until the last act in the conspiracy was performed. And so it's all within 5 years of February 2019. Or I guess it would be within 5 years of October 2019, going back. And we have number 8, Giannulli, and 14, Loughlin. The grand jury hereby alleges that the defendants, with others known and unknown to the grand jury, to commit the following offenses: to conduct and attempt to conduct financial transactions, to wit, bribe payments, and other payments funneled through a purported charitable organization and a for-profit corporation, knowing that the property involved in such transactions represented the proceeds of some form of unlawful activity, and which, in fact, involved the proceeds of specified unlawful activity, that is, mail and wire fraud and honest services mail and wire fraud, in violation of Title 18, Section 1341, mail fraud. It's called frauds and swindles. 1343, fraud by wire, radio, or television, and 1346, conspiracy. I think 1346. mail fraud, wire fraud, and attempt and conspiracy to commit one or both of those. But they only said it's one count of a violation of this that carries 20 years. They haven't alleged 2 counts. Let's see. And knowing that the transactions were designed in whole and in part to conceal and disguise the nature, location, source, ownership, and control of the proceeds of specified unlawful activity in violation of Title 18, Section 1956, A1B1. And here we have the A2A specific allegation. This would be Loughlin and spouse. To transport, transmit, and transfer, and attempt to transport, transmit, and transfer monetary instruments and funds, to wit, bribes and other payments to a place in the United States from and through a place outside the United States, with the intent to promote the carrying on of specified unlawful activity, that is, mail and wire fraud and honest services mail and wire fraud in violation of Title 18, those 3 statutes. Now, this could be the emails that they exchange back and forth. She got a phone call in the Bahamas, and so those are places outside the United States and in interstate commerce. So I feel they sufficiently triggered the jurisdictional question on these essential elements, and this is right out of the statute again. So those are the 3 counts against Lori Loughlin, and that's why I feel bad for her, because she's got trouble, and it's not good at all. Let's see here. I'm going to go to takefromcaesar.us. Let's see, is that where? No, here we go. Federal sentencing grid. Now remember, in my calculations only, okay, none of this is legal advice. Here's the sentencing grid I like to reference right here. And what we see here is from junior to badass, right here, 0 or 1, that's prior criminal history. No history or 1 offense. 2 or 3, the number of months goes up, doesn't it? 4, 5, or 6, a repeat offender. You've already done 4, 5, or 6 crimes, more months. 7, 8, 9 criminal offenses in your criminal history, lots of months. And 10, 11, 13 or more. Look at the difference between 13 or more. In Zone A, which would be probably the misdemeanor, 0 to 6 months for your first offense, 15 to 21 months if you got 13 or more counts behind you in your criminal history. So over here, Lori's a first-time offender. And how many months are authorized by those counts? Oh, let me see. 45 years times 12. That's a lot. And so it's a lot. And in the plea agreement, not at trial, in the plea agreement, the prosecution can say, we agree to ask for no more than 30 months for this plea agreement. Wow, I was up on 45 years worth of charges, and they only asked for 30 months. And then the judge is going to look over here and say, excuse me, but I can't accept 30 months on 45 years worth of charges. And they're going to have to recommend more time to please the judge. So they're going to have to go to the judge and say, how about 63 to 78 months to get her into Zone 26, or in Zone C at number 26. We agree we won't ask for anything more than 63 months. And as you go down this list here, there's a couple of interesting dynamics. You get 2 points off for acceptance of responsibility. Maybe it's 3 points in this category here, offense level. So they'll bring you in and say, okay, we're going to sentence you soon, and you come out at a recommended 30 on this offense level score column. 30 carries 97 to 121 months, but you pled guilty. and you accepted responsibility. You apologized and threw yourself on the mercy of the court. Okay, we can take off. Let's say it's 3. And so we go up here to 27. That's still 70 to 87 months in prison. She's in trouble. And I hate to see it. And now that they've dialed up the charges on her, a person who I think is an idiot that said, don't plead guilty, we're going to trial. When they turn up the charges like this, 45 years on an actress for 2 acts of fraud, my goodness. So she's in trouble. And she wanted to play hardball with the DOJ, and here she goes. So when they look at this sentencing grid, it'll be the far left column. There's no criminal history. But the number of years, 45 years, what are they going to let her plead guilty to? Not that 5-year charge, probably one of the 20-year charges. So 20 years, 20, that's 240 months. Oh, but we agreed to only ask for 78 months with the category 28 because she pled guilty and accepted responsibility. We'll bring her down 3 grades and just give us 78 months in prison. However that works out. This is how deeply into the trouble she has proceeded. I'm going to go to trial. This is what you're facing. And I'll bet you this wasn't shown to her before she decided to go to trial. You paid university staff $500,000 in bribes to fool the university into thinking both of your daughters were experienced in crew. If the government can prove any of that, she's in trouble. And I'll bet you they'll take off 1 count of conspiracy to commit wire fraud and 1 count of conspiracy to defraud the United States and leave one of the 20-year charges left for her to plead guilty to. Or she's going to go to trial on all 3 charges. And this is trouble. My heart goes out for her. It's nice lady, and you just can't do this. If you want to argue lack of criminal intent, you'll be laughed out of the courtroom. If you want to argue void for vagueness, how would somebody of an American's background, where you're deprived of knowledge of the law clear through school? I didn't hear the word statute till I was already out of community college. And you can't even handle a traffic ticket because they keep you ignorant of the law. And then they make the law so complex that nobody's going to open the criminal code and say, how much time can I get for this? And an argument could be made saying she can't reasonably be expected to understand that it could cost her 45 years in prison. And I don't know what court you're going to get a deduction of months off the sentence for that, but it'll come in the form of lenience. It won't come in the form of a dismissal of the indictment. You can believe that. So, Lori Loughlin, I think even if the judge is nice to her, he can't justify giving her less than maybe 48 months or 60 months. That's 5 years. Because the government can appeal a sentence that's too lenient. And whatever circuit she's on, I think she's in California, it'd be the 9th Circuit. It has to get past that court. So the judge can be really lenient and the government can appeal it saying she's got to have more than that. So Lori Loughlin and her advisor, they've dug a hole for themselves. The advisor gets to stay out of jail. He's the attorney. And the other 2 are in deep kimchi. Massimo Gianelli. I'm going to destroy the guy's name. He doesn't deserve that. Massimo Gianulli and Lori Loughlin, husband and wife, are in trouble. and they're not going to go to the same prison. Okay? They probably won't be in prison in the same state. And I imagine Nevada's got not a cushy facility, but a facility in Pahrump. That might be their first stop on their way to their destiny, but if they're doing 5 or 6 years, they probably won't start in a camp level security federal prison. That's one with no fence around it. You walk off the property, you're a felon, but they'll probably be in a low level, which means you got tall fences, razor wire, and sniper towers, and have to do the majority of their time. Then they might be transferred to a camp. California has a couple of nice camps. And Lori Loughlin is facing 45 years worth of charges. She had the chance to plead guilty to something and said, I'm going to trial. That didn't come from her head or her husband's head. Somebody said, we can go to trial on this. Because if I was her counsel, I'd say, this is bad. And you need to plead guilty while you can, because they got the goods on you. Those facts, I feel, a four corners analysis of this indictment, and yeah, there's record of the money transfers, there's the false photographs, the history of the daughters that'll prove there's nothing about Crew anywhere in their past. So they got the goods on Lori Loughlin, and I'm really sorry to say that. So my name is David Merlin. This has been a not-so-brief review of the Lori Loughlin indictment. And, of course, I wish her the best. And I got it. Please, sweetheart, you really screwed up. And 45 years seems really steep for somebody that doesn't know the law. But at the same time, purchasing something falsely by falsifying documents and getting that property of a university handed to you by fraud, there's just simply nowhere to hide. Again, my name is David Merlin. I'm your host. Thanks for visiting here on YouTube, my channel called Take from Caesar. I'll see you in the next tutorial.